When you are working as a real estate professional, you will need to have a solid understanding of common documents and agreements used in real estate transactions. One of the most important and most common documents you will encounter is the Standard Purchase and Sale Agreement. This is a legal document used to specify and detail the seller's and buyer's intentions, acknowledgement, and understanding of the sales transaction they are engaging in. As a real estate professional, you should know how to complete the contract. So, in this lesson, we will walk through each section of the agreement in detail. We'll start with Section A, Key Terms and Conditions. Item 1 includes information about the property being sold. This includes the street address, MLS number for the listing, the property tax parcel ID number, and the legal description as recorded with the county. By entering into the agreement, the seller warrants that they can deliver marketable title to the property described in this section. Item 2 is fairly straightforward and includes the agreed-upon purchase price for the transaction. In Item 3, the amount the seller or sellers agreed to contribute at closing is listed. This is also the spot to document the closing costs the buyer will pay, as well as prorated items such as association fees and estimated taxes. Item 4 asks for the closing date agreed upon by the buyer and seller, and, if different, the date the property will be turned over to the buyer. At closing, the seller is expected to deliver all keys, garage door openers, and codes giving them access to the property. Under certain circumstances, either the buyer or seller may unilaterally extend the closing date by up to 8 days. That is a one-time right, and it can only be exercised in extenuating circumstances, as described more fully in Section B of the agreement. Item 5 is a spot to document who will hold the buyer's earnest money. This person or company is called the holder, and there are some very specific requirements about how the money must be maintained. The money must be put into an escrow account no later than 5 banking days after the date of the agreement, or 5 banking days after receipt of the funds, whichever comes later. If the holder is the closing attorney for the transaction, they must complete and sign additional forms, F510 and F511. In Item 6, the person preparing the agreement will document the closing attorney or law firm selected by the buyer. Item 7 includes the agreed-upon amount of earnest money the buyer is putting down with the agreement, and whether the earnest money is being paid by cash, check, or wire transfer. The earnest money is intended to show the seller that the buyer is serious about the transaction and intends to follow through with the purchase. Under certain circumstances, the buyer will be entitled to a full refund of the earnest money. For example, if the seller defaults on the agreement in some way, or if there is a contingency under the agreement that is not met, the transaction will be canceled, and the earnest money will be returned to the buyer. Otherwise, the earnest money is applied towards the purchase of the property and is factored in at closing. Item 8 covers the parties' agreement about inspection and due diligence for the sale. The person completing the agreement form should document the time limit for the buyer to obtain an inspection, appraisal, or conducting other reasonable due diligence. If, through the due diligence process, the buyer finds something material and wants to cancel the contract as a result, they can do so without significant penalty. However, they must exercise that right within the specified time period in Item 8. Alternatively, the parties can agree to an as-is transaction, which is not subject to a due diligence period. Item 9 asks about the existence of lead-based paint on the premises. If any structure on the property was built or manufactured before 1978, the seller must complete and attach a separate lead-based paint exhibit, Form F316. In Item 10, complete information about both the buyer's broker and the seller's broker in the real estate transaction. If both the buyer and seller were represented by the same real estate brokerage firm, they must acknowledge and agree to dual representation, even though the parties' interests may not be aligned at all times. By signing the agreement, the seller agrees to pay brokerage fees as established in the separate listing agreement, which is incorporated into this agreement by reference. Finally, Item 11 indicates how long the buyer's offer is on the table for consideration by the seller. If this time period expires without the seller either accepting or rejecting the offer, the buyer is no longer bound to the terms of the agreement. If the seller accepts the offer and delivers notice of acceptance before the expiration date and time have passed, then the parties have a valid contract for the purchase and sale of the property. You should read and familiarize yourself with Section B, which provides more in-depth information, instructions, and definitions about item numbers 1 through 11 covered in Section A. Now, let's turn to Section C, Terms and Conditions. Section C provides additional legal information about the agreement itself. These paragraphs were designed to aid in the parties' interpretation of the agreement and to govern any disputes about the contract itself. For the purposes of this lesson, we will cover these provisions at a high level. You should take the time to read the agreement in its entirety and ask questions as needed, so you understand what your real estate clients are agreeing to by signing the purchase and sale agreement. Item 1 addresses any notices either party is legally required to give the other under the agreement. Such notices must be in writing, must be legible, and must be signed by the party providing the notice. Notices must also be delivered in a manner that complies with the specific requirements outlined in this paragraph. If the parties' brokers are not acting in a dual agency capacity, then providing notice to the other party's broker counts as providing notice to the other party. In other words, a buyer who wants to provide a notice to the seller about their intention to cancel the agreement based on information learned during the due diligence period could provide a written, signed notice to the seller's real estate broker rather than having to provide it to the seller directly. Item 2 under Section C addresses what happens when either the buyer or the seller default on their contractual obligations. If the buyer defaults, the seller is entitled to keep the earnest money, but does not have any other recourse. If the seller defaults, the buyer can either demand specific performance, meaning they can demand that the sale goes through as planned, or they can cancel the agreement and get a full refund of their earnest money and any other money they had put down towards the purchase. In the event either party defaults, that party is contractually obligated to pay the commissions the brokers would have earned had the sale closed as intended. Finally, in this section, the parties also agree that if there is a legal dispute or arbitration, the party who does not prevail in that matter will pay the other party's legal fees. In Item 3, the seller is warranting that they will deliver the property in substantially the same condition as it was when the agreement was signed. and that personal property, trash, and debris will be removed. This provision also contemplates the possibility that there will be significant damage to the property after the agreement is signed but before closing. In that event, if the parties do not cancel the agreement, the seller agrees to return the property to substantially the same condition it was in so the sale can continue. In that event, the closing date and term of the agreement are amended. Item 4 includes language saying that if the property is condemned before closing, that the seller will promptly notify the buyer, who then has the option of canceling the agreement within 7 days. In this part of the agreement, the parties agree that they will cooperate with each other, give consent for sharing necessary non-public information, and agree that electronic signatures will be treated just like traditional signatures. The remainder of Item 4 includes some common contract provisions governing the agreement, including a choice of venue provision, saying disputes will be subject to Georgia laws and heard in Georgia courts, and that time is of the essence with this type of agreement. This section also includes a statement that the parties acknowledge that they are not required to use forms like this one, prepared by GAR, the Georgia Association of Realtors, and that the forms, as written, may not meet the parties' needs. In Item 5, you will find basic definitions for terms used in the agreement, including banking day, binding agreement date, broker, and business day. Item 6 warns the parties that cyber fraud in real estate transactions is a real danger. It explains some of the ways cybercriminals may attempt to defraud either the buyer or seller, so the parties can be on the lookout for and avoid becoming victims of such criminal activity. Item 7 is a spot for the parties to include and reference all additional forms and exhibits that will become part of this agreement. There are many different types of exhibits the parties may need to attach. Here is a brief overview of some of the most common exhibits attached to Georgia purchase and sales agreements. FHA Loan Contingency Exhibit, F407. Most home mortgage loans are insured by the FHA, the Federal Housing Administration. Lead-based paint exhibit, F316. If the home or any structure on the property being sold was constructed prior to 1978, the seller must complete and attach this lead-based paint disclosure form. Seller's Property Disclosure Statement, F301, F304, F307, or F310. This disclosure statement gives the seller an opportunity to identify any and all material defects in the property. The purpose of this document is to provide transparency so the buyer knows what they are getting when they purchase the property. Closing Attorney Acting as Holder of Earnest Money Exhibit, F510. In Georgia, only attorneys can act as closing agents for real estate transactions. It is a common practice for the closing agent to also hold the earnest money. When they do so, this exhibit must be completed and attached to the agreement. The final page of the purchase and sale agreement provides spots for the buyers and sellers' contact information and signatures, and the contact information and signatures of their brokers. There is room for 2 buyers' names and 2 sellers' names. If there are additional parties to the agreement, you can complete and attach an additional signature page, Form F267. Understanding the ins and outs of the purchase and sale agreement should help you as you prepare draft agreements and answer basic client questions about the form.